afternoon, everyone. We are letting folks into the room right now, so we'll give them a few minutes to get situated. Want to give a huge shout out to our fellow ACEDS DC chapter board member, Tony Vines, who's been really instrumental in putting this together. Her and the awesome team at Control Risk have a really cool topic they want to discuss today. Updated trends around digital forensics on mobile devices. I think a lot of us have seen a lot of things in the news, whether in government, private side, corporations, law firms, and cell phones are obviously can be very tricky. I think it's also something, the amount of data. And then obviously, I think from my world in government, how do we timestamp and get that information to not overburden the investigation as well as the client situation and the cost. So there's an awesome team at Control Risk, Michael D'Angelo, Tara Allport, Allison Smith, and Brad Klozinski. They're going to go through their expertise, their background. Obviously, I invite them to share a little bit more of how they got into this situation here and provide their expertise. I'll turn it over to them in a few minutes, but I really want to thank Tony Vines doing an awesome job putting this together. I'll announce it at the end, but I want everyone to save the date. Tony has put together on September 18th, our good friends at Control Risk, putting another webinar. So invite a friend, invite others. Social media investigations and analysis. Obviously, that has become a huge thing. We're back in the day, we just pull emails. Now, I think social media, and not only it's multiple platforms that are out there. So that's going to be September 18th at 12. So be sure to do that. We also want to thank our other folks on the board who put together events for us. James Perkins from Innovative Driven, Julian Ackert from iDiscovery Solutions, our good friend Monica Harris from Monica Harris Consulting. So we have exciting things coming up. Also, we want to save the date for our eDiscovery Day, which really celebrates what has been going on. So I think most of us in this world have realized how fast things have been going with generative AI. We have a lot of AI experts overnight. So stay in touch. Big thank you to Tony Vine, the Control Risk team. Michael, I'm going to turn it over to you to kick off this conversation and share a little bit about yourself and your fellow presenters.
Great, thank you, Nick. Just one change. It's just gonna be me presenting today. So
Sounds good, sir.
I'll introduce myself in a minute. Let me just get this presentation shared out. Nick, do you mind passing me screen share control, please? There we go. Okay. All right, so let's go ahead and get started. I assume that everybody can see my screens to the presentation intro there. Welcome and good afternoon to everybody. Today's webinar titled Trends Around Digital Forensics on Mobile Devices. My name is Michael D'Angelo. I'm a principal here at Control Risk. We put this webinar together to discuss issues that have been plaguing digital forensic analysts, experts, and practitioners for years, but also to discuss and introduce kind of some legal concepts that are relevant to our cases in investigations, bring up some new and ever-evolving topics that we should all be aware of. We have a little bit over an hour together, so there's a good amount of content to get through. We'll be moving quickly, and I'll be talking a lot as I usually do. So any questions, please hold for the end. But any content that we don't make it to, I'll gladly share with any one of you. Please feel free to reach out to me directly after the presentation. This might feel a little bit exhaustive to some of you, but it's certainly not all the information that we could talk about when it comes to mobile devices, digital forensics, and how it relates to eDiscovery. So again, if there's anything that I missed or you'd like to discuss further, please feel free to reach out to me. Today's agenda will be, I'll be introducing today's overall topic as well as myself. We'll look at issues that have given us headaches historically. issues that have evolved and we're dealing with currently and in the future. We'll discuss how AI has now crept into mobile devices and what that means for investigations and analysis. We'll move to historical and recent cases as well as litigation. We'll look at ever-evolving legislation and law that affects mobile forensics. And then lastly, we'll take a look at some of the issues that are coming on the horizon as mobile devices evolve and consumer technologies change as a whole. And then lastly, we'll save a few minutes for some questions and comments at the end. So to get started, today, again, we're going to be talking about trends around digital forensics as it relates to mobile devices. So why is this important? It's a very important topic because we probably all own at least one mobile device here on this call. Nearly every adult in the United States has at least one mobile device, and there's virtually no investigation where mobile devices are not relevant or potentially relevant. The majority of investigations are going to involve some sort of data set that potentially could be on a mobile device, whether that's messaging data, application data, something that's cross-synced from maybe a business application or a cloud account. Almost always something that we need to take into account and think about. You should care about this topic because data coming from mobile devices can be particularly important. Some of the technologies, applications, and services on mobile devices are becoming increasingly more difficult to access, and the requirements surrounding mobile device data as it relates to investigations and litigation is also changing. So not only is the technology itself, but kind of the controls and regulations around those technologies, they're changing greatly every day, every month, every year. So it's important to stay on top of these just because, like what I just said, the relevancy of some of this mobile data to our cases is growing. People that should hear this include attorneys, lit support specialists, security officers, IT admins, e-discovery analysts, regulatory advisors, really anyone who's in a position to deal with data requests, e-discovery, or forensic analysis, and those in charge of policies that directly impact mobile device usage and data retention. So who am I and why am I qualified to talk about this topic? As I said at the beginning, I'm Michael D'Angelo. I'm a principal at Control Risk. We're a risk management global firm. We consult on many different fronts. I am part of a specialized group called the Discovery Plus Data Insights practice, where I head up digital forensics and incident response here in the US. I've been working in digital forensics for over 15 years. I have a bachelor's degree in criminal justice, associates in information assurance, associates in information security, master's in digital forensics, and an MBA in business administration for technology. I started my career with the Department of Defense, led multiple forensics teams, investigations and analysis, then headed to the Manhattan District Attorney's Office, where I led I was one of the lead cyber investigators in the cybercrime unit. And I've been working with many of the mid-sized, large consulting firms over the years across a broad range of engagements and investigations. I testify regularly on issues related to digital forensics and analysis. I've analyzed thousands of devices, and I've acquired data from tens of thousands of devices over my career. I also teach on these subjects. So I teach digital forensics in multiple universities in New York City. I'm a self-confessed nerd. I really just love technology overall, but I really enjoy learning how new features and devices work, how data is stored, how it moves around, and ultimately how we can get at it. How can we get at that data to be useful for our purposes? But first, we're gonna touch on some of the historical mobile headaches. Um, there's quite a bit. They still exist. They've always been around. They're changing. They're evolving. But we'll talk about some of the standard ones that we've faced kind of over the years. So some of the difficulties that we face with mobile devices that you're maybe aware of already. First being multiple connections, right? So mobile devices don't just make phone calls. They don't just send text messages. They have multiple ways of communicating with each other as well as with other devices. This could be done through USB connections, technologies such as AirDrop or Android Share. NFC, near field communication. Obviously, we can transport data over Wi-Fi, Bluetooth, many other types of platforms in which we can share and disseminate information. That means that data could be shared that way. It can also be accessed this way. So when we talk about securing devices, when we talk about how data might have ended up on a device, how it was shared to another device, we need to keep all these different mediums in mind. Um, due to all these different connection methods, isolating or disconnecting from other sources, it's very important to keep all of these different facets in mind to avoid changing data, making updates to data that's maybe already been received or stored, as well as the concept of remote deletions. And we'll touch more on what that looks like and what that means. Mobile data in and of itself, it's very hard to isolate and very volatile. And what do I mean by data being volatile? We've probably all seen pictures of conventional hard disk drives that come out of computers, little platters where data is physically written to those storage mediums. Mobile devices work much differently, much more closer to modern day laptops, or like a solid state drive where data is constantly in motion. Data is changing, it's being moved around. Every time we boot up that device, anytime a application is launched, we receive a notification. Anytime we receive an app update, there's going to be changes to that device. So data has the propensity to change over time. It changes based on the actions that we're telling the device to undertake. And these are all things that we really need to keep in mind when we're handling mobile devices and ultimately looking at the data that we've extracted from those devices. We're also probably all aware of the sizes of mobile device storage dramatically increasing over the years. When mobile devices first started hitting the market, we were looking at 5 gigs or less of storage size. Now we're looking at devices that can contain a terabyte of data or more in some instances. The reasons that's important. Number one, it's just a lot more data to look through, but it also slows down acquisition or imaging times. It increases the amount of time that we need with a device. So it means that users are also going to be storing much more data and saving that sometimes locally to their devices. So not only is there a time issue here, but we also need to think about the amount of potential data that's going to ultimately make its way to review, whether that's multimedia, data coming from applications, and obviously an increase in messaging data as well. Consent is one of those issues that's always been here. Users or custodians giving us access to devices, companies giving us access to systems or devices on behalf of their employees, and then obviously trying to get access to personal devices. Consent requirements, they change depending on jurisdiction and the personal devices versus business devices. There's also those kind of gray areas, right, where personal devices are used for business purposes, and certain users may demand that only certain subsets of data be collected and not others. This historically has always been an issue. It continues to be an issue depending on the device, depending on the situation, the jurisdiction, and the type of engagement that we're involved with. From a digital forensic standpoint, not only the size of devices, but also the consent issue. We need to keep these in mind when we're actually collecting devices. It's going to have a direct impact on how long analysts are staying on site or that they need with hands on that device. It's also going to throw a wrench into the mix when we're talking about possibly covert collections or collections that need to be done kind of outside of normal business settings. We need to keep that in mind when we're talking about time requirements. Smartphones are being used for new uses every single day. This comes with an ever-growing amount of data that's available on these devices. So as the capabilities grow, as the application count grows, users are taking advantage of that and using their devices in ways that maybe we haven't thought of previously, or we're just seeing entirely new applications and data sets emanating from these new usage and capabilities of those devices. There's no one of the really difficult situations that we've been in historically, and I would say it's starting to kind of coalesce nowadays. But the lack of standardization. No two manufacturers produce the same mobile device, and no two mobile devices in the wild are exactly the same. That's due to, the settings that we can put on our devices, the customization that we can put onto our devices. It also includes just the number of devices that we see on the market, the varying versions and adaption rates of devices out there, as well as the increase of operating system updates that we receive, as well as application updates that we receive on our devices. In addition to that, historically, there is no shortage of the amount of different charging cables or connection cables that we've seen in the past. I said that that's starting to change. We do see it coalescing around kind of like Lightning and USB-C type connections. So usually most forensic examiners are going to have at least a Lightning and a USB-C cable. But historically, for older phones, for different jurisdictions globally, different countries globally, um, we talk about the varying different connection cables that we're gonna have to have on hand. Additionally, uh, the types of data that can be exported through particular cables has changed over time, with USB-C and Lightning really giving us full access to a lot of the data that exists on devices. I had touched on updates, but this is an important topic, and we'll talk more about this in a second. But updates can change where data is stored. It can change how data is stored. It can change how applications interact with your mobile device. They can also add capabilities to user experiences. I mean, we've seen this with the introduction of ephemeral messaging, editing of messaging, customization of emojis and stickers and widgets on devices, as well as the ability to put enhanced encryption protocols and security protocols in the hands of the user. Um, so these are all things that could be changed and updated as these updates are rolled to our phones. It's important for forensic examiners to stay on top of these and share these details with attorneys or clients, keeping them abreast of what's possible and what's not possible at any point in time. Encryption has, and the near future probably will remain, one of the largest headaches that we have with accessing user data. Encryption on mobile devices is becoming very good. Encryption comes baked into almost every mobile device that we receive from manufacturers nowadays. So accessing data on newer mobile devices without PIN codes or passcodes can be virtually impossible in some situations. Most applications are building in their own security layers as well. Think of things like WeChat, WhatsApp, Signal, Telegram. They give you the opportunity to encrypt local databases as well as end-to-end encryption on communications. iTunes backups. So Apple has added the ability of users to add another layer of security to iTunes backups, which starting in iOS 12, I believe, required backup passwords to be added to any data that is coming out of an iOS device. So this means that any data exported from an iOS, like an Apple or iPad, will automatically be fully encrypted with an independent password. Oftentimes, we can bypass this requirement, but if all that we're working with is a backup that's been delivered to us, and if it is encrypted, we would need that PIN code or passcode to access that data in and of itself. So sometimes working with backups is a good option, but not always if it's fully encrypted and we don't know the PIN code. Similarly, security features like Samsung Knox, some other companies like LG are now coming to the market with their own security solutions as well. These present additional issues in accessing data and exporting data from devices. The tools like Knox are meant to protect and bifurcate personal from business data, but they've grown in complexity and adoption. And it's a shining example of manufacturers adding their own security apparatuses that make forensic collections much more difficult. So this kind of adds to the idea that we need to understand what we're working with before we get down the line to having to actually review data. We want to know what devices are in play at the get-go. That means understanding make, models, sometimes even operating system versions, because we want to get ahead of any issues that we might see or be presented with when trying to get data off of the phone, or ultimately trying to parse it and access it and make it, accessible and readable for review purposes. And then lastly here, one of the newer issues that we've been dealing with is cross-syncing of ecosystems. So what this means is if you're an iOS user, if you have an iPhone, a MacBook, and an iPad, you may see that your iMessage is syncing across all of those devices. If you're an Android user, you'll certainly be seeing that documents saved on maybe your mobile phone is now popping up on your Gmail or your Google Drive account, which you could also have synced to computers or even your Android tablets. So this presents issues surrounding authentication, origination, and it also sometimes presents issues where we're hoping to determine origination of data, which device it may have emanated from or been created on. We'll touch more on that in a few minutes. Some of the emerging issues that we're looking at, and some of these have a lot of crossover with the historical headaches that we've dealt with over the years. They're kind of just evolving in their own way. And then we see some new issues coming about as well. So FBE versus FDE, the difference here. So FBE is file-based encryption. This is historically what we've seen on Apple devices and Android devices, where the data itself is fully encrypted. This would also mean that most devices are shipping with FBE enabled. User data is locked, needs to be unlocked by the user at startup. So we've all seen this. We turn our phone on, we get presented with a kind of a splash screen to enter our PIN code, enter a biometric, or whatever the case may be to unlock that device. Samsung and LG are two examples of manufacturers that are pushing full disk encryption from a manufacturer's level. Apple is doing the same as well, and many other Android providers are starting to do the same. And this full disk encryption, the difference here is that a password is required at boot. So when you've initially can you guys still hear me? I'm sorry.
Yes, sir.
Okay, there we go. Sorry, I thought I dropped the call for a second. So as I was saying, full disk encryption is now coming from many manufacturers. And what this means is there's their password requirement as soon as you start that device up. This means that the operating system as well as the data is inaccessible. It makes it much more difficult for us to access that data. And it's something very similar will be coming to all manufacturers in the near future. So it's going to be very important that we understand and make very clear to custodians, targets of investigations, legal counsels, that PIN codes, passcodes, biometrics are going to be very important in order to access data in the future. End-to-end encryption is being pushed out to virtually all messaging platforms out there. We see it popping up more and more often. So what this means is not only will the application sit behind its own security layer, but individual messages within a conversation are encrypted and oftentimes inaccessible. Some of you have probably seen this when you're reviewing text message communications or messages coming from various platforms, most notably WhatsApp, one of the most common messaging platforms we see out there. WhatsApp, Facebook Messenger, they've both recently released end-to-end encryption. So this means that instead of seeing the content of some of the messages, sometimes you'll just see a placeholder saying that this message is protected and fully encrypted. There are some ways around this. They could be quite complex sometimes. Working with custodians, the owners of the devices, makes it much easier to get at this data and make it viewable or accessible. Additionally, sometimes when there's end-to-end encryption, having both ends of those conversations, so having devices that are the sender as well as the receiver, also give us a little bit more leeway in getting access to those communications. We've also seen an increase of the number of and adoption of data protection solutions, mobile device management systems by companies. These types of data loss prevention applications and other monitoring technologies often make collections more difficult and almost always require intervention from IT or security teams. So when dealing with enterprise level solutions, when dealing with investigations or litigation pertaining to organizations, large companies that have something like this involved, it's going to be necessary to work with IT or security teams to understand how they've implemented such a monitoring system, what restrictions are in place on those devices, and what security settings might need to be removed or modified in order to get data off of those devices. It is not uncommon to have organizations blocking the ability for applications to run on a device. So you won't be able to install unapproved applications. It's also very common that businesses will prevent the export of data from mobile devices. And it's also very common that organizations will further restrict even things like taking screenshots on those devices. So these are all things that we need to be aware of when we're walking into situations where mobile devices are in play, usually at a broader level, and that we know are potentially being monitored or managed by some sort of centralized management system. The frequency of application and operating system updates, something that I just touched on the former slide. But we do see an increase in updates overall that are getting pushed to our devices. Major and minor operating system updates are coming at a faster frequency than they have historically, and application updates are being pushed to our devices almost every day. Usually these are small bug fixes, minor fixes to features that maybe were acting incorrectly or users have just thought that there was a small bug in. But sometimes this has the propensity to change how data is stored, where it's stored, and in what manner it's stored. Sometimes major changes also introduce new capabilities. So we need to be aware of what capabilities are being introduced or changed. If you go back, think of the introduction of something like Snapchat. Snapchat is an application that is used quite often by younger generations, and the draw to something like Snapchat is the idea of ephemeral messaging or messages that disappear after a period of time. In the first introduction of Snapchat, those messages were sitting in temp space and could be recoverable for some period of time after their deletion. Usually you had to get to that device quickly, but oftentimes data was recoverable. At least records of data were recoverable. Nowadays, that has changed. The ability to get at data that has now since been deleted, the time period has shrunken dramatically. Sometimes we can't recover that data at all. Other times we need to just rely on logs to show that a message was sent at this particular time between these parties. Other times there's virtually no data that could be recovered, depending on the application and the type of message that was sent. We also see not only an increase of updates, updates from an application standpoint, but also an increase in the frequency of the devices that are released to the market. We just had a Google Pixel event last week where a whole new range of devices were released. That's less than a year since their last major release of devices. Apple is notably on basically a yearly release type cycle as well. But from other manufacturers like Samsung, LG, OnePlus, they're releasing devices at a faster clip. And this type of frequency may increase over time. Maybe not same device lines, but we do see an ever expanding expansion of products out there. So introduction of additional tablets, mobile devices, things like phablets now that kind of are crossbreed, wearable devices and smart devices that plug into these ecosystems as well. Data synchronization has kind of always been an issue, but we're seeing that much more often nowadays. So data synchronization means data from mobile devices are oftentimes syncing to and from other devices that are tied to user cloud accounts, such as Apple iCloud or Google accounts. This can often lead to issues with devices sometimes not syncing properly, questions about surrounding origination of certain data points, or requiring access to multiple devices that may have varying access controls. So we often see messages that may not appear on a mobile device. We go to maybe the same custodian's iPad and we see the other end of that conversation. Or we might see an Android mobile device where certain pictures aren't loading because they weren't saved to the device. We can't find them in temp space. But then we go to the user's Android tablet and we can see all the multimedia fully intact over there. So just keep that in mind with the newer types of devices and the cross syncing of these ecosystems, data synchronization across different devices. It sometimes may require that analysts have to access both physical devices as well as cloud accounts or backups. Cloud solutions have also added their own security controls. These are separate from mobile devices and often require multiple steps to authenticate access. So we get asked quite often, the user lost their phone or they don't have access to it right now, or they simply don't want to give you physical access. Can an iCloud backup or an Android backup suffice? Oftentimes the answer is yes. But if we don't have a clean backup of that device, and let's say we now need to log into iCloud in attempts to pull down a backup, that's going to require multiple levels of authentication. I'll use iCloud as an example. Generally, when you try to pull down a backup from iCloud, we're not only going to need the user's iCloud username and password, but a one-time push code is going to be sent to the phone or iPad or other iOS device. They'll need to authenticate themselves there. And then we'll need to also sometimes produce a code to then authenticate ourselves on our forensic tools and machines that are trying to pull that data down. One layer above that, that's simply just accessing the iCloud backup. Once you have the backup down, there may also be encryption in play. So we would then also sometimes be beholden to the encryption passcodes or PIN codes that are set up for that particular backup. Third-party apps, there's millions of them on app stores. Like I said earlier, no two phones are the same. No two individuals use their phones the same. And the types of apps, the number of apps, and how we use them changes from individual to individual. Third-party apps store data, sometimes in proprietary formats that are not generally standardized across devices or even platforms. This can include complex data structures, sometimes encrypted files or databases, and forensic tools must be specifically designed to handle these proprietary formats, which can vary widely between different applications and even between different versions. So we're constantly kind of in a cat and mouse game, playing catch up to app developers, mobile device providers, and operating system developers, where we may understand how an application like Instagram is storing data today, but a major release may come next week, and now it changes our understanding of how that data is stored, accessed, and ultimately secured on a mobile device. We'll not only need to better understand how those changes have taken place, but we'll also have to create fixes or sometimes wait for fixes and updates to our forensic tools to be able to access that data. And I know that could be a really big pain point in litigation. Oftentimes, litigation moves quickly. Investigations, are ongoing, and they're not going to be held up by a single data point. But this is just kind of a fact of life. Our mobile tools, our mobile forensic tools and analysis tools are almost always going to be playing catch up. to how app developers and mobile device providers are handling data on devices, what kind of new security features and encryption protocols they're implementing, and then storage and usage settings that users have access to and control of. We, we also need to think about the ever evolving regulations and laws. Data privacy laws are changing and they're different from every jurisdiction. Uh, Control risks, we deal with many international type investigations that are spanning across different countries. So keeping in mind what data sets, what types of devices, what needs to be asked before we can actually touch any devices or export data from devices is going to be of utmost importance. Understanding what privacy laws come into play depending on the location and the jurisdiction. Forensic investigators need to navigate these regulations, which sometimes can vary significantly, all within a singular or unified investigation. We need to ensure that compliance with legal standards while performing forensic analysis. It can complicate investigations, especially when dealing with international data uh, and data that might be coming from sources that are also overseas. And then lastly, chain of custody. You're probably all familiar with the idea of chain of custody, the ability of investigators or analysts to authenticate data and maintain a clear chain of physical custody of device or different data sets. When it comes to mobile devices, though, this sometimes can present a tricky subject. Maintaining a secure and documented chain of custody, it is critical to preserving the integrity of evidence, but however, the complexity of mobile data and the rapid evolution of technology can make this challenging. Um, that's due to the reasons that I was just talking about, cross-syncing among different devices, data being pulled down from clouds, data residing on servers or solutions that exist in other countries, the large swing nowadays to remote collection. So we're not necessarily taking physical custody of devices, we're taking kind of like logical custody of devices where mobile device may still be in the hands of a custodian, but we're pulling data off of it remotely. Um, these all present issues when trying to explain and document chain of custody. Any lapse in proper chain of custody can lead to questions about the authenticity and integrity of the evidence, potentially impacting the admissibility of these findings. So additional scrutiny, what we've been finding, additional scrutiny has been given to mobile data authentication and chain of custody more recently. As the legal world becomes more and more aware of potential issues here, we're getting many more questions around chain of custody efforts, tracking of evidence, evidence intake practices, et cetera. Mobile devices are a critical piece to many investigations. And like I had said earlier, the volatility of this data, the sheer amount of data that could be found on mobile devices, oftentimes makes them very relevant to our investigations. So having a clear, concise chain of custody on those devices is very important. So just to touch on the cross syncing, Apple iCloud, as an example, gives you the ability to sync data across different devices. This means that content may be mimicked across multiple devices, but it also might mean that data could exist on one device and not the other. It could be deleted on one device and not the other, or it could be removed from all devices at once, depending on how a user has their settings and iCloud backups set up. The other issue that this presents when devices are cross-syncing or syncing with a cloud is that we may have a user that has 2, 3, 4, 5, maybe iOS devices that have varying levels of security and authentication protocols. So when we start an investigation, we may think that our scope is for a singular mobile phone that individual uses for business purposes. But then we find out that they're having that business phone synced to their personal iCloud account. And within that iCloud account, we see that they have 4 other personal devices that are synced to the same iCloud account. There's a potential that that same data that's being used for business purposes on their business iPhone could be cross-syncing to their personal devices. This may require that additional devices be collected. It may also necessitate analysis of those devices to determine what data may be missing from that personal device, or establish where any holes or dark spots are when comparing to all of these devices in totality. So one of the newer features in iOS devices is a little unknown feature called handoff. Apple Handoff allows for a universal clipboard. So what this means is you can copy and paste data across different devices. Very useful from a consumer standpoint, right? So I can copy a text message that somebody sent me, drag it over to my iPad or my MacBook, and now I can paste it into an email or maybe even to a Google search, something like that. Very useful from a consumer standpoint. But it does create new and interesting quirks for analysts where we must determine where data originated from or where it's potentially copied from. These are things that require a little bit more intricate know-how, a little bit more in-depth forensic analysis, and an understanding of how operating systems are storing, sharing, logging this type of information. So again, not to beat a dead horse, but this is why it's very important to stay abreast of and on top of new updates that are being pushed from application developers, as well as manufacturers and operating systems. Another new feature that's hitting mobile devices and different messaging platforms is the ability to edit messages. Now, this has been around for a few years now with applications like Instagram, Facebook Messenger, but now we see it fully integrated into iMessage as well as Google Messages, the ability to edit messages. It can be found in almost every messaging application now, and it's sure to be found in almost all messaging platforms in the future. This does present an authentication issue on a message level where content may be changed. And oftentimes we'll need to look at associated information to determine what data may have been edited, what messages were edited by whom, when, and potentially questions surrounding what was the original content. Depending on the application, the device, the time that has passed since that edit, there's varying levels of likelihood in whether or not we're able to determine these points. But it would almost always require that a forensic analyst dig a bit deeper in order to answer these questions surrounding originality, the time of edit, and similar questions that might arise due to these new features. This is certainly going to become a bigger headache in the future as edited messages become points of contention in litigation. Wearables are also becoming very prominent and much at a much higher adoption rate. So wearables, uh, much more available to the market. We're seeing them become much more common in litigation and investigations. Again, here we see an origination issue. So we're having issues determining where data may have come from or whether or not it exists locally on a mobile device versus some of these smarter wearables. Some wearables are fully standalone LTE devices. So some wearables can control smart devices, mobile phones. They even have their own mobile number and LTE capabilities. So determining where a call originated from, where a text message might have been sent from or edited from. These are all important topics to keep in mind in investigations, especially when it surrounds questions about originality, about authentication of those messages, and sometimes data from these wearables can also be useful investigations when determining individuals' physical locations. Additionally, wearables really highlighted and put a spotlight on new data sets that are oftentimes related to investigations, and that includes health data. So wearable devices are constantly taking things like metrics like heart rate, breath rate, oxygen levels, obviously location, number of steps, method and mode of movement directionality, stuff like that. These can all be very important when trying to place somebody at a particular location or to determine, somebody's physiological statistics at the uh, point of a crime when a crime was undertaken. One of the hottest topics in technology, e-discovery, litigation is AI, artificial intelligence. It's it's you know there's varying understandings of artificial intelligence, how it operates, where it's being used, how it's been used in the past historically. But one clear indication from companies like Apple and Google is that they're certainly riding the AI wave, and they're integrating more and more uh, AI laced capabilities into our mobile phones. So the two prominent AI capability assistants that we see being pushed to mobile devices are the recently announced Apple Intelligence and the Google Gemini, which has been around on Pixel devices for about the past year or so, but making its way to the broader public just now. Some of these capabilities we kind of are aware of already, so I'll discuss some of these in depth. Some of these we may not be as familiar with. But these are things that are coming to every consumer's devices, and we'll certainly see them further baked into these devices in the future. This is not an exhaustive list, as we're still learning more and more about how AI is being integrated into products and services, but it's meant to highlight some of the more useful and concerning features from a litigation and investigation standpoint. Everyday users are taking advantage of AI features today, but this integration and adaptation will grow drastically in coming months and years. Apple Intelligence, pretty new, still getting rolled out to the wider market and newer devices, but it has the capability to automatically summarize conversations. It can summarize web pages, articles, and post directly to notes, emails, or text messages without any user interaction besides giving a prompt. This raises additional questions about origination and possible issues of accuracy, right? So if there's questions around a user sending a particular text message to another custodian, and they've basically asked Apple Intelligence to summarize an email and send it to one of their partners in a text message, but the heart and soul of that email has been lost in translation. When it comes time to litigation and review of those messages, are we then reviewing a text message that may not succinctly be summarizing the nature of an email? Will there be questions around origination and whether that user actually meant to send that text message? Or was that just something that our phone automatically put together for us and sent on our behalf because we had a more general question about an article or an email that we've read? Apple Intelligence also has the capability to find and reference, or excuse me, find a reference within a message or an email and launch content based on that reference. So an example of this would be if a friend is referencing a particular podcast, let's say in a text message or an email, Apple Intelligence will automatically see that reference and then launch the podcast that the email is referring to. Another example of this could be, let's say a coworker is texting a friend about what the weekend forecast might be, or restaurants in a particular area. Apple Intelligence has the capability to see that question, launch the weather app, or launch the Apple Maps application on your device, summarize and provide a list of what's going on, what the weather will be in a particular area without user action. So as this capability grows over time and as user actions and tendencies are learned in more detail, these actions become quicker, they become more ingrained, and they become part of kind of our normal interactions with mobile devices. This is certainly going to lead to struggles within investigations, deciphering between what is a user action and what is an automated event. It's not going to be easy enough to just say, oh, a text message was sent to this from this phone to this phone. It must have been Mike that sent that text message, or it must have been Mike that launched Google Maps and entered this search inquiry. We are now going to be dealing with questions surrounding, was it the user? Was it an automated AI event? Or was it some sort of secondary prompt that came from a different application? Apple has also sprung up a close relationship with ChatGPT. Additional features are going to be built in over the coming year and over time. But what we know so far is that Siri will be passing off more complex questions and prompts to ChatGPT to resolve in the cloud. Results will then be passed back to Siri for delivery to the user. And again, this adds potential issues of personal or company data making its way into ChatGPT's AI models, as well as issues in determining original prompt criteria by investigators. A little bit off topic, but somewhat related, is the idea of Microsoft Copilot. If you're an Office 365 user, you may have been exposed to Copilot. This is the Microsoft's AI implementation on in Office suites. Companies do have the ability to set up their own Copilot models within the organization. So being able to query and analyze what prompts and results were provided within an organization is a little bit easier. But when we're providing prompts to Siri and then ultimately ChatGPT, becomes a little bit more difficult to understand or determine what prompts necessitated a particular feedback or output. So there's going to be certainly additional questions about that going forward. Google Gemini also gives users the ability, really great, but sometimes scary capabilities to edit photos, like removing people from photos, changing backgrounds, refocusing and reframing photos. This is certainly going to, again, lead to issues of originality and also authentication when it comes to photographs and multimedia. Gemini also allows users to create photos from text prompts. We've probably all seen this on the news. Other applications like Dolly do the same thing. There's going to be questions about origination, about copyright issues, editing. All of these are going to be legal issues that we're going to be dealing with on a mobile level very soon. Gemini, another, from a consumer standpoint, great feature. From an investigation standpoint, worrying feature is call summaries or call notes. Gemini has the ability to listen to, document, and summarize calls and save that as a note to your phone. So again, questions arising around the succinctness and effectiveness of those summaries and whether or not a user had any interaction in creating that summary, editing it, or using that summary for further business purposes. Other things such as smart replies. If you're not familiar with smart replies, these have been around for quite a while now. So within a text message or messaging chat, you might see the ability to click on a particular response, automated response. Google's been providing these for quite a while. It reads the messages and then provides automated responses that it thinks are in nature with the sentiment of the conversation. Gemini builds on this, and it gives you the option and ability to change the tone, the theme, or the idea of a response automatically. So some of these are more amusing, like they have a remix feature where you can change the theme of a response or a message, things like Shakespearean speech, or you can have it write in chill mode. These are kind of silly and novelty, but they do present legal issues around attribution, origination, and ultimately the message itself, the authentication of that message. Was it the user writing that message out, or was it Google Gemini creating an automated message based on what it believed the concept of that conversation to be? One issue that we haven't talked about enough, I think, in legal world with AI and clouds overall is the dissemination of private and personal data to AI models, whether that's purposefully or accidentally. Once company data is shared with AI models, it's going to then be used in determining answers for other users. So there's propensity to expose that data to other users. This is very important to understand and keep in mind for companies, and especially in terms of litigation and investigations. The growing AI feature list. These are things that we're seeing being built in slowly and being released to the market over time. So things like blurring of photos. Mobile AI, Apple Intelligence is giving the ability to review multimedias and blur out sensitive content before it reaches a user's eyes. We don't really know how this is going to affect forensic collections or images when images that have been blurred are not accessed or unblurred before the point of collection. This is something that we'll figure out over time. We also don't really have our heads wrapped around why a photo would be given a particular sensitivity tag. But these are all things that we need to keep in mind when we're looking at mobile images and ultimately multimedia that we might be analyzing after the fact. Generative AI, we just touched on. So things like the introduction of Chat GPT, Gemini, Microsoft Copilot within our messaging, going to be producing automated messages that maybe a user didn't have a hand in actually creating. Automated facial recognition has also been around for quite a while, but within things like iCloud albums and Google Photos. But recently, the introduction of AI gives users the ability to run searches on photos that are a little bit more subjective. So things like search photos for John with ketchup on his face, or search photos for friends making silly faces. These are prompts that you can run against albums and have actual results returned to you. It's going to become very difficult for investigators to determine what those outputs could have been when we're analyzing what prompts or searches a user ran on their mobile device. Google and Apple AI can also recognize text. This should be very familiar to everyone on this call, with the idea of very similar to being OCR, or optical character recognition. It's a feature in e-discovery workflows that have been around for a long time. But Google gives users the ability to basically pull text out or translate text without even having to capture the media. So you can point your phone at a particular sign or banner, and without the need to actually take the photo, Google Gemini can translate it on the fly. So for investigators, we might see particular output that was made available to a user without seeing the input, because no photo was actually taken of the original media. We also see the increase of automated searches. So like I was just saying, Apple AI and Google Gemini will be triggering in-app searches or in-message question via prompts that have been raised in the form of communications, the form of messages coming in, or just somebody trying to get a summary of maybe a long conversation or a long article. These automated searches, again, raise issues of who was actually running that search and origination. Another, it's in a similar vein here, is automated posts. So Apple AI has also stated that they'll be giving the ability for iPhones to create create captions for social media posts on the fly based on its review of the media that you're uploading. So let's say I upload a vacation photo to my Instagram or my Facebook. Apple AI will automatically create a caption for me that it thinks is in line with the nature of the photo. Again, this is going to create issues of authentication when it comes to legal proceedings. Was the custodian the one that in fact created that caption or that response? Or was this more of an automated event by an AI model? So now we'll be talking about recent cases. We're gonna breeze through this a little bit. Number one, because I'm not a lawyer. Number two, most of you probably understand the case decisions better than me. Number three, technology is moving so quickly that decisions quickly become outdated. And number four, much of this applies to law enforcement or the government, but still pretty important to know. So we'll look at some of the mobile device precedent historically, starting with Riley versus California 2014. This created precedent from the Supreme Court stating that seizure or searches, incidents, or arrests officers are required to obtain a search warrant to acquire and access data from mobile devices. The thinking behind this is that data available on these mobiles is extensive and personal in nature, equating our mobile devices essentially to a locked filing cabinet that contains our deepest and darkest secrets. This does have a direct impact on law enforcement, but has varying levels of impact on corporate or private investigations. US versus Worry. This reinforced the Riley decision, stating that officers cannot violate the Fourth Amendment rights by searching call logs specifically. Um, Carpenter versus US. This extended the need for warrants when accessing user location data from mobile providers. So in the course of investigation, sometimes the whereabouts of an individual become necessary. And we can get that information from call detail records or from ISP providers, but these oftentimes do require a court order or a warrant to do so. Google LLC versus Oracle, although not specifically focused on mobile devices or forensics in general, it did have a focus on fair use and reuse of code. It focused on Google products, the development of them using Java code, and it does relate to forensic and investigations in that digital forensics tools leveraging connectors to other tools, plugins, or custom adoption of third-party code potentially was being perceived as infringing on copyright laws. However, this case was able to put that discussion to bed. And additionally, this had an impact on analysis of code and programs where copyright infringements or intellectual property theft was of most importance. So forensic tools nowadays that we use to analyze code differences between codes, this case has a major impact on how we can decipher between applications that are similar or being reused or stolen from other entities. State versus FAM. This stated that users cannot be compelled to provide biometric data such as fingerprint or facial information in order to unlock a mobile device. The Oregon State of Appeal or Court of Appeals ruled that this is a violation of Fifth Amendment rights and in violation of individuals' right against self-incrimination. US versus Morrow created an exception to the warrant requirement in relation to mobile devices, and this exception was made to an imminent risk of data loss due to remote wiping. And this is a topic that is extremely relevant to mobile device investigations and data that we would pull off of devices. Find My iPhone, Find My Android are services that allow users to actively see where the devices are, and it also gives them the ability to remotely wipe or lock their devices, blocking access to data. So it's very important to understand this, especially when we have adverse parties or the investigation might be highly contentious. There might be a risk of data spoliation or data deletion, or we're just dealing with nefarious actors that have reasons to delete data. It's important to keep this in mind, and there's a carve out made for when that potentially could happen. So here's some future precedent that may be hitting the books soon. People versus Pardo strengthened US versus Morrow decision that data obtained from mobile devices without a warrant can be used when an imminent threat exists. State versus Sturgeon is still ongoing, but it's testing the limits of compelling users to provide biometric details to unlock devices. US versus Johnson deals with this deals specifically with an individual possessing child pornography on a mobile device. They were sentenced and they entered a plea agreement to not be prosecuted for further related offenses. However, authorities proceeded to search the device and found additional incriminating material, which resulted in additional charges. This led to a debate on limits to consent where it comes to mobile devices and areas of analysis. So we see a major issue with consent, users giving access to devices, sometimes not at all, certain subsets of data, certain areas or applications on those devices. So we're waiting feedback on that case to see how that's going to shake out. US versus Myers is also ongoing, but it'll help determine the limits on when data from mobile devices can be forensically collected and the potential risk of data loss exists. Um, People versus Garcia is, again, another case about searching mobile devices and acquiring data without a warrant, where suspicion of remote wiping may be in play. So again, the awareness of remote wiping capabilities is very important. Consumers understand it. There's a very much higher adoption rate and usage rate of things like Find My iPhone or Find My Android nowadays. And uh, consumers are becoming much more aware of the ability to remotely wipe data. Historical regulations. So historical regulations, things like the Communications Privacy Act, allows companies to sue employees who misappropriate confidential information. So this gives organizations the ability to let's say an employee leaves an organization, they move to a competitor. Company can use the CFAA to protect itself from the risk of losing or compromising confidential data. And it does give a foothold into the notion that personal devices may need to be analyzed and inspected. Um, Computer Fraud and Abuse Act similarly gives organizations kind of that window to look at personal devices of users that have brought devices into either the workplace or using them for personal uses as well. And the federal rules of evidence, although longstanding, has a carve out federal rule 902 that requires electronic evidence to be authenticated. What this means for electronic data is that it must be authenticated and it must be reliable. So generally, we do this with hash values. We prove that the data that we're bringing into court is the same data that existed on that device. With mobile devices, very difficult to create hash values to re-image mobile devices and obtain the same data. It's like I said at the top of this webinar, data is constantly in motion, constantly changing, being stored in different ways. So authentication and chain of custody is very important when it comes to mobile devices. Newer legislation, GDPR, I think we're all aware of GDPR and the kind of the requirements when European customer data is involved. This is true for mobile data as well. SOX 404, part of Sarbanes-Oxley, requires controls over financial record keeping. So in the modern world, this definitely includes data that can be found on, created from, or shared to mobile devices. More recently, SEC Rule 2042, this is similar to SEC's updated Rule 17A4, which we'll talk about in a minute, except this is particularly concerned with record keeping of advisory firms rather than broker-dealers. FINRA Rule 4511, it's very similar to the SEC Rule 17A4. Again, we'll talk about that in a second, but it requires business activity records to be retained for a minimum of 6 years. We're finding this increasingly includes mobile communications and data that's found or accessible by mobile applications. Many companies are having difficulties or troubles adapting to this rule as well as SEC Rule 17A4. They're finding that as the workforce gets younger, the adaptation of novelty applications like Snapchat, Telegram, Instagram to share business updates and talk about business are increasing. So companies are dealing with issues on how do we get to that data, how do we retain it, how do we make it searchable, and ultimately how do we make it accessible in the future if need be. SEC Rule 17A4 is a consequential update to the SEC rules. This is around broker-dealer retention policies and preservation of communications. It's specifically focused on firms and their requirement to implement backup procedures to ensure records are not lost or destroyed. This also includes procedures for managing and preserving electronic records. So it puts a full burden on firms to actively identify, preserve, and justify the integrity of all business-related communications. Again, like I had said, this is becoming increasingly difficult for financial clients due to the growing number of ways to share information, share communications, and the difficulty to get at those communications on employee personal devices, business devices, and within applications that might be personal in nature or have some sort of apparatus like ephemeral messaging or end-to-end encryption. Last year, the DOJ also introduced additional guidance where that applies to all companies, not just regulated entities subject to the SEC rules, but it requires that company practices on the use of personal devices, messaging applications, and communication platforms be assessed. So if you come under DOJ scrutiny, they're going to add additional scrutiny to companies' policies, the environment, risk management framework around proper mobile usage and how records are maintained. On the horizon, what are we going to see in the future? So we're seeing a ever-growing interest from various states as well as federal governments in implementing new and novel data protection laws. Personal privacy laws and adjustments to consent requirements are also coming. This trend looks to be ever evolving with lots of room for the US to grow. This will also lead to increased scrutiny from various government organizations and likely to increase the responsibility of parties to protect, preserve, and document data that is passing through or related to their business. And with the introduction of AI systems into mobile devices and applications, there will be an increase in automations that we each take advantage of on a daily basis. Things like smart message replies, triggered actions like an AI assistant reading off top emails when wake up alarm sounds, automated searches when our phones are near or pointed at something of interest, many more situations that we can't comprehend right now. We don't know the full extent of how AI will be integrated into mobiles, but we can be sure that it will raise more questions about what actions were human and what were automated or undertaken by our devices on their own. When we receive a new message, a new file, new image, or text content on our mobile devices, the trust aspect is assumed. However, in many cases, there is no accurate indicator of trust, right? So when we receive a message from John Doe that we know, there's no active indication that we can trust that it is actually John Doe. But as we advance, we will see trust indicators on mobile devices in the next few years, making information consumption safer and hopefully more reliable. Generative AI highlights the need to focus on data security, privacy, and trust. We'll be more dependent on our phones to look at and determine what content is original versus what is generative. Most people agree that mobile devices are becoming more and more sophisticated and may eventually be comparable to our everyday computers. And no one knows for sure, but many predict that there will be a renaissance where mobile devices not only are our primary device in our personal lives, but the singular device in our lives, a device that can control all other secondary systems, one that we use as our main computer for work, entertainment, and browsing, with full keyboard and visual capabilities, ability to expand, the ability to handle more robust and application and software suites. So with that, I will move to questions and comments. I will open up the floor. We have about 10 minutes, 10 minutes or so. Any questions that I can answer for you all?
Michael, while we wait for folks to generate their questions, one coming up in a month, very relative to this presentation, is iOS 18, which is going to have a huge AI implication. What do you see being a challenge with iOS updates or any phone updates for this area that we've been discussing this afternoon?
Yeah, I think one of the biggest issues kind of that I beat home today is going to be the authentication issue. What was actually user created versus what is generated by AI. So we're going to have issues of authentication. We're also going to have issues of attribution, whether something was created automatically without any user action, whether there was a prompt to that creation. We're going to have issues of determining what that exact prompt was, right? So we might be able to see output. We might be able to see a timestamp of that output, but what was the action that the user took to actually generate that output? Those are going to be major issues. I think what we're also going to see with further integration of AI is our phones. If you think that they're customized to your liking now, they are going to be much more customized to our individual likings in the future once AI understands how we interact with our phones on a daily basis. So the idea that no two devices are the same is going to be increasingly notable in the future. I think forensic analysis and investigations are going to spend a lot more time determining how a user is actually using this device day to day and why certain applications were being launched in the background or certain triggers that are happening day in and day out based on a learned user experience with that particular device. But these are all questions that I have myself, that I think that most experts have themselves. We will see. The verdict is still out on how this is going to unfold.
And I guess a follow up to that, it just seems to be leading into the theme of more data is coming.
Yes.
And how do you tell the story if you're the investigator, a regulator, court, in front of a board? How do you tell that without having to go through millions, if not billions, pieces of data to find the smoking gun or lack thereof regarding a mobile device?
Yeah. So I think you know I think one way to battle AI is with further AI, right? So we are seeing a growing trend within e-discovery and forensics of the adaptation of further and additional AI capabilities as well. So not only can, like, Apple AI and Google Gemini and ChatGPT summarize articles, text messages, emails, but e-discovery platforms have and will have better capabilities in the future to do the same against massive amounts of data. We're starting to see it with Microsoft with their introduction of Copilot, giving investigators and analysts the ability to actually probe and analyze what inputs and outputs were hitting their customized Copilot models. We hopefully will see such advancements in the future for consumer-based AI models, but we are certainly going to see that in e-discovery AI models that we can hopefully sift through haystacks much quicker to find that perceived uh, needle in the haystack.
And I guess to push it further, since we're talking about mobile, what if we see the virtual reality market take off? Is that just gonna expand even
Yeah,
further? Instead of having, you mentioned, the phone could be coming back, laptop, computer may be going away. But if we now have a virtual desktop in front of our eyes, what does that do to the collection aspect?
yeah. I think the issue that like AR and VR present is kind of the issue that I touched on with active translation, things like Google Lens, live transcribing, where you can just point your phone, and it doesn't have to be a phone, obviously, right? We have like wearables now in the form of glasses. We have pins out there, all these different devices that are becoming part of our bodies. That the issue is going to be, what was the originating input? Will we be able to access what that user was looking at, or what they asked to translate, or what did they ask to to view? Because things like Google Lens are doing it on the fly using a processor on board, but also cloud computing capabilities. So me taking a photo of something and then asking my phone to pull text out of it, that's a little bit different. I should be able to go find that photo and see what processes were taking place on that mobile device. But if I never have to take a photo of something and I'm walking around the real world and I point my eyes at a particular business and ask Google to run a search, where does that live? Where does that live in the cloud? Will there be some remnants on the device itself, on the wearable? Will it pass through the phone? These are all things that we're going to have to, actively figure out throughout the years to come.
Yeah, no, these are great issues. I think we're all trying to figure this out. And I mean, it also goes to, I think we brought up GDPR in California as well. We don't have a US privacy, but where do we see privacy? I mean, we all remember the San Bernardino cell phone
Yep.
issue, the Apple still, you can read their letter about privacy. Um, but we also see there's hacks every day. So how can organizations, government, and individuals protect privacy on a device, but then when we need to get at it for investigations, or whether criminal, civil, or litigation, how do you see that happening?
Yeah, I think from a corporate standpoint, um, it's definitely a good idea to take advantage of the mobile device management platforms that are coming to the market. We do see, larger and mid-sized companies taking advantage of that. So they're able to push their own security apparatuses to mobile devices and really lock them down to their liking. It also protects, Google, protects business data. You have the ability to kind of bifurcate personal from business data. It allows businesses to protect themselves when maybe individuals are walking away from the company, joining competitors, potentially walking away with intellectual property. That's one of the better ways. I think also, reassessing BYOD policies, bring your own device. Those are things that companies need to take into account, especially industries like financial industries, healthcare industries, where the data they're dealing with is highly regulated. We see more and more companies kind of moving away from BYOD and actually issuing devices so that they have greater control of and the ability to retain that data. From a personal standpoint, I think you know application developers and manufacturers are certainly siding with consumers, implementing additional security encryption protocols. And I think most consumers that's welcomed from an investigation, law enforcement, government standpoint, not as welcomed, but understandable, right? So there's always going to be that trade-off between personal protections versus how we're going to make it easier for investigations and government analysis. I don't think we'll ever come to agreement on what's the proper trade-off there. We'll always have examples of, like you said, San Bernardino. Um, in those extreme events, I I have faith in forensic providers and manufacturers that they will work on and figure out solutions to those one-offs. But in the grand scheme of things, I think the level of security and encryption that developers are pushing to phones and applications is only going to get better. It's only going to get better from a consumer standpoint.
That's interesting. I mean, you brought up BYOD where we can save a few bucks, but then when it gets down to litigation, that nominal saving is just outweighed. And I think anybody who has multiple phones on them, I'm excited to see that the fanny pack is coming back in where you can have all 3, 4, 5 year devices because you got a watch, you got an iPad, you got personal phone and work phone, but it's nice to segregate them. An interesting thing that I heard last week is there was a corporate report that said 25% of companies say people use generative AI in the workplace. Same report asked employees and was over 70%. So that becomes a challenge when an individual is on their personal phone, their work phone, or the same thing embedded together. And something's going on, whether it's antitrust or somebody's trying to hide trade information or potentially rob a bank. How do you kind of get that information and work with great experts that control risk so that the company can have a really expert plan? Because obviously, as we all know, this can get a lot of data where if you have good policies in place from the beginning, this can maybe limit, but you always have your rogue employees. Michael, I'm going to give you the final word in 2 seconds for future predictions, but I want to thank Tony Vines, who's at Control Risk as well, helped organize this awesome discussion. A lot of great information. She dropped her email in the chat so you can get the presentation that was presented today. Also going to follow up to get the recording that we did for our ACEDS members out to the group there. Be sure, I'm going to hit it again, as we talked about mobile. Obviously, social media has its challenges out there. I think it's safe to say there's not just one social media platform that an individual may use. So that's going to be September 18th at 12. Good friends at Control Risk are going to be putting that on. Be sure to register for that. Invite friends. If we saw it today, I mean, I was blown away by the presentation. So excited to see social media. So the last minute, Michael, go ahead and give us your closing thought on predictions.
Yeah, I think I'm gonna just build on what you were just saying. I think the onus is definitely being pushed to organizations and companies to better protect themselves and abide by the requirements that we're seeing evolving here in the U.S. and across different jurisdictions. I'll admit that the U.S. is a little bit behind in the evolution of these laws, but they're coming, and companies, legal counsels, security groups need to be well aware of what the requirements are of them, limitations that just exist inherently in technology, the usage in which their employees and individuals are partaking in their mobile devices, and just really taking into account how to better protect themselves and make data available when they become subject of an investigation. these are all things that, we think about daily, we help our clients with, and, we're here to help.
Excellent. Thank you so much, Michael, for your time and your expertise this afternoon. Really appreciate it. Thank you all for our attendees for stopping by and hearing the discussion. Look forward to seeing you again on September 18th, 2024 at 12 p.m. Hope you enjoy the rest of your afternoon.
Thank you, everyone.